Assalamualaikum warahmatullahi wabarakatuh. We are from Group 2. We are going to present Task 1 and Task 2. Our Task 1 title is Our Risk Policy. These are our group members. For introductions, our risk policy covers all losses or damage to the insured property except those expressly excluded in the policy's wording. It is therefore essentially the responsibility of the insurer to prove why a loss would not have been eligible. Insurer and insured. Insurer is a Takaful operator, for example, Takaful Ikhlas, and it is mentioned in the proposal form. Meanwhile, insured are clients who provide information about themselves and their coverage, forming the basis for Takaful certificate. Type of insurer: contractor or risk, Takaful Ikhlas Berhad. Takaful Ikhlas General Berhad is an Islamic insurance firm based on Islamic teachings of sharing responsibility and cooperation. The policy covers engineering insurance for works over a predetermined space called the work site and indemnifies the insured party against any damage during the period of insurance. These are the risks insured. First is physical loss or damage. Second is property in transit. Third is liability coverage. Fourth is fire and explosions. Fifth is existing property. Next is premium. The term premium describes the sum of money that a person or organization must pay for Takaful coverage, which is insurance policy. For example, premium rate for constructions is determined by taking account of project costs, sum insured, geographic locations, and period of testing. Risk assessment is the primary method that insurers use to calculate premium fairly with the existence of precise and relevant information that is needed. For conclusion, to manage risk in line with Sharia law, Our Risk Takaful offers an integrated approach to the management of risk that provide protection from a range of unforeseeable events. It offers a valuable option for individuals and businesses who seek to obtain complete ethical risk management solutions by means of flexibility and mutual aid principles, although some exclusions are applicable. Next, let's move to the Task 2. Our Task 2 title is Insurable Interest.
Okay, moving on to the facts of the case. It is identified as Civil Appeal number S4 August 2003 in Malaysia. The story unfolds from its origin in the Session Court, initiated by lawsuits known as Summon number 52031996 and number 52041996. The key players appealing the case are Chang Kuo Ping, who also goes by Richard, and the dissolved entity Sri Germawan Sendirian Berhad. As we delve into the complexities of this legal journey, it becomes evident that these appellants are dissatisfied with the outcome at the Session Court and now seeking a different resolution, taking their case to a higher court. Next, for the parties and policy, the people who are making a claim, which is plaintiff, bought a special insurance policy from a company called Malaysian Assurance Alliance Berhad in 1988. This policy covered a group of vehicles, including a logging truck. The incident that happened was a brake failure, causing the logging truck to overturn in Kapit, Sarawak. Now, the plaintiff are asking for the insured amount 250,000 ringgit plus interest and the cost associated with the claim. For the defendant defenses part, the defendant is using several defenses. They are challenging the right of the plaintiff to bring the case, locus standi, questioning the truth of the claims made against them, and pointing out a lack of disclosure in the information provided. Additionally, the defendant argues that the plaintiff shouldn't receive the entire insured amount they are claiming. The case moved up to the Court of Appeal in Malaysia. In their judgment, the Court of Appeal thoroughly examined the legal arguments presented in the case. Their decision is not only comprehensively address these arguments, but also offer a clear and final resolution to the dispute between the plaintiff and the defendant. I think that's enough for the facts of case. Let's move to the next presenter. Thank you.
There were several issues that we discovered. First issue that is being considered in Chung Kuo Ping's appeal against Malaysian Insurance Alliance Berhad is whether Chung Kuo Ping or Richard had ownership interest in the vehicle involved in the accident bought at the time of insurance policy creation and the incident leading to the loss. The second issue where the plaintiff can avoid the special perils policy and repudiate liability on ground 5 in the case of question 3 on the defendant's specific indemnification policy form, it is alleged that there was misinterpretations or failure to disclose matter facts.
I will continue the presentation. As my friend told earlier, in my case study, the plaintiff not registered the legal owner and were not covered under the insurance policy. Second, the court cited cases from the Asia Insurance Co. Ltd versus Tat Hong Plan Leasing Pte. Ltd. 1992, which ruled that insurance contracts can be avoided due to misrepresentation and non-disclosure of material facts. The plaintiff sued the defendants for avoiding the policy and claiming the money paid was paid under mistake of fact. Second cases is insurance in China, Insurance Co. Ltd. versus Ngau Akau 1972. The plaintiff claimed that the indemnification of car losses by the defendant's company argue false declaration. The federal court ruled that answer become the terms of the insurance contract and the defendant deny liability. The principle of Thomson Wims stated that contracting parties can make actual existence a condition before contract inception. Okay, the third cases in Dawson versus Bonham and Ors. The claim was the insured lorry's fire loss, with a misstatement in the proposal form affecting the policy. The court ruled that untrue statement or breaches of promissory clauses would avoid the policy. However, condition 9 of the policy stipulates that the truth of the statement is a prerequisite for liability. The appeal was dismissed with cause. Number 3, the case was dismissed with cause and a deposit was to be paid to the defendant to account for taxes costs. I think that's all from me. I will pass the presentation to my friend. Thank you.
Next, we discuss regarding judgment of the court. The appeal case revolves around the original suits filed by Chung Chao Leng Timber Co. Sdn Bhd and Rapid Growth Sdn Bhd, which were discontinued. As we figure out, plaintiff purchased a special perils policy for logging operation near Telopet and Tawaf since 1988. A worker named Ricardo was involved in a logging truck accident in Market, Sarawak. The defendant reprimanded the plaintiff's insurance policy, claiming they did not have an insurable interest in the unregistered logging truck which were involved in an accident. The second plaintiff, Sri Gamawan Sdn Bhd, registered the vehicle in 1995 despite the accident and resumed a release later from B Trucks Sdn Bhd. The Session Court judge found that the plaintiff allegations were irrelevant as the insurance policy does not identify any of the four appellants. Unfortunately, the appeal case was dismissed.
Next, for my part, which is party argument, there are four plaintiffs involved in this case, which are Richard Sri Gamawan Sdn Bhd, Chung Cholong Timber Contracting Company Sdn Bhd, and Rapid Growth Sdn Bhd. The defendant is MAA, or known as Malaysian Assurance Alliance Berhad. The plaintiff claimed that they were the legal owner of a logging truck and filed a claim for Rm250,000 and costs against the defendant based on allied loss and damage to the truck. The defendant denied some of the allegations made by the plaintiff, questioned their right to bring the claim, and argued that the plaintiff failed to disclose all relevant facts about the insurance policy. Additionally, the defendant claimed that the plaintiff were not entitled to recover the full amount of the insured sum. That's all.
Okay, next for the commentary. In the view of the judgment, based on the facts and argument put forward by all parties, we can make a conclusion that it is appropriate to rule in favor of defense. Insurance, as defined by law, between an insured and the subject matter of insurance is a legal right arising from financial relation. Anyone who purchases insurance for any asset shall prove that they have an insurable interest in the well-being of the insured asset. The insurance contract cannot legally be enforced by the insurer or the beneficiary without such insurable interest. In accordance with the principle of insurable interest, when an agreement is concluded and signed between the parties and the contract, they are expected to be willingly obligated to do so. In this case, the plaintiff claim as aligned in paragraph 4A, B and C of the amended statement of claim does not constitute loss covered by the insurance policy because the lodging truck were not attributed to accident collision. In this case, the insurance policy will exclude the plaintiff action and they are not entitled to compensate in law. Furthermore, the claim made by the defendant is irrefutable. The driver of the lodging truck is completely negligent and contribute to the careless. The driver of the lodging truck had loaded up with the timber logs exceeding its capacity to hold them, so that it was not possible for the brake system on the lodging truck to have been sufficient. Under those circumstances, the driver failed to take all appropriate precautions that would have prevented injury or loss of such a lodging vehicle. Moreover, the applicant did not submit any evidence that either misrepresentation or alteration to the lodging vehicle was made in breach of its manufacturing requirement. The plaintiff has refused to disclose any prior claim history. The defendant has no obligation to the plaintiff or any of them under the insurance policy since they have failed to make full and honest disclosure or are otherwise guilty of non-disclosure of the key fact as stated above. Also, the defendant's application should be accepted as the plaintiff failed to prove that the first plaintiff no longer had ownership over the vehicle Kenwood lodging truck since it had already been transferred to Sri Kemawan Sdn Bhd in March 1995. Since the insurance policy does not include a legal entity, it does not include the name of any of all plaintiffs. This case has revealed some of the difficulties that will be encountered when lack of the clarified prevail within the legal and regulatory framework. The aim is to provide a system of guarantees that applies solely to those who have made genuine investment in the good health of an object with a view to promoting responsibility risk management and equitable distribution of insurance premiums.